大家好，我是曾博荣律师，我也是阿凯迪亚的副市长。谢谢你来我的频道，律师怎么说？我发觉说，华人经常来美国的时候，有很多的问题，其实他们都一直在脑海里面，不知道怎么答复。所以我希望说，我们这个频道可以帮助我们的华人。谢谢。
In an employment case, when it comes to me, I typically say that there are two main types of cases that come to me. Things that are outside. Outside, I would say, are going to be wage claims. And things that are inside. And what are inside? Inside are things that you can't see. Discrimination is a huge one. Harassment is another one. Those are all cases in California, and in some ways that happen on the inside. Now you have to understand, although we have many clients that speak English very well and we handle a lot of mainstream clients, we do have a lot of clients that English isn't their first language. We have people that speak Spanish, we have people that speak Chinese, people that speak Korean, and so that's the way I kind of explain things. Now, things on the inside, because it's hard to see, I always tell the employer this: what would the most ideal employer do in a situation that's presented? So if an employee comes up to you, for example, and says, hey, Tim's been harassing me, would the ideal employer look at Sarah and say, well, Sarah, Tim's 70 years old. He's not harassing anybody. If he could harass somebody, you should be happy, Sarah. You should feel lucky. No, the most ideal employer wouldn't do that. Now, the reason why I use that example is because it happens all the time. An employee will come up to you and will say something that you may feel is completely ridiculous. It doesn't make any sense. How could that happen? Well, in a situation like that, you should always ask yourself not to be subjective, but to be objective. And to be objective, I always tell the employer, it doesn't matter how you feel, just ask yourself, what would the ideal employer do in a situation? If you go under that direction, 99% of your actions are going to be correct. Now, earlier I talked about you need to hire an attorney to do categorization of your workers correctly. I'm not saying that you shouldn't hire a law firm, but many times your HR, as well as a business owner, many times they're making on-the-job decisions. Somebody comes up to you and they say, I feel uncomfortable. I don't like Tim. I don't like Bob. I don't like Joe. And in situations like that, you have to make snap calls. In a snap call, my reaction is that I would always recommend to the employer to do what the ideal employer would do in your head. And if you do that, you will find many of your actions are going to be in compliance with the law. Now, here's a problem that employers frequently encounter, which I completely understand, and that is a lack of documentation. You don't like an employee doing something, and you feel very uncomfortable about the employee doing something. That is very common. And so what an employer will do is they'll typically verbalize their complaints, their concerns, over to the employee, and hopefully the employee will be able to correct it. But when there's a dispute, what ends up happening is that the employee will have a story, totally understandable, and an employer will have a story, totally understandable. But the problem is in California, because you are going to face a jury, usually, jurors are typically employees. They're not employers. They don't understand that employers struggle with not wanting to embarrass somebody, not wanting to write somebody up. But unfortunately, in California, you're really going to need to do that. Now, in terms of writing a person up, this is the big question. Many people feel that if you write somebody up, you have to let the employee know. California law does not require that in any way. If you have a concern with an employee, document it. If you have a problem with that employee, write it down. Even if it's an internal memo between you and HR. It's not a California requirement to give the employee notice that you have a written warning against the employee. In fact, many jurors have said to me that they're very concerned that if the employer had a problem with the employee, that they never documented it at all. Juries in California are a funny bunch, and it has nothing to do with them being employees, it's a fact. A juror, although they are not required to in any way be prejudiced, in many ways they are prejudiced. They aren't able to understand that hiring employees is very difficult. They aren't able to understand my story of going out and buying food for my employees and not being able to eat dinner and eating their leftovers. They can't understand that. And because of that, you have to be able to run your business as if you're going to be presenting your case not to employers, but to employees. And there's nothing wrong with that. That's a fact of litigating in California and really all across the world. If there's any opportunity to be in front of a jury is going to perceive life as if they're an employee. They're going to think things are reasonable based upon their perception of what's right or what's wrong. And it's not necessarily a prejudice, it's just how they feel. So in terms of the things that are inside, there are, again, discrimination, and there's going to be harassment, retaliation, failure to accommodate, a lot of those issues. My recommendation has always been you can hire an outside law firm to do the investigation for you. It's not expensive at all. Now, why would you have a law firm be able to do that for you? So you can be able to lean on the law firm to be able to say that you made an objective investigation over a complaint that happened at work and you complied with the recommendations that are given. Typically what happens is that an employee that goes through an investigation never considers it to be reasonable. They always say that HR is going to stand on behalf of the company because HR is hired by the company. They're not really sitting in the middle. And so what many companies have done, and I think wisely, has hired law firms to be able to come in to do the investigation and to be able to make the determinations and the findings of fact and to be able to give recommendations. Now, here's the problem when you hire a law firm to come in. Tim, that you really like, the law firm could make the conclusion that Tim did sexually harass somebody or that Tim retaliated against somebody. In a situation like that, if the law firm recommends that Tim needs to be terminated and you don't terminate, that could be a very serious issue. And hence why many employers don't want to hire outside law firms. Because if a law firm comes in and they're hired to make the determination and the investigation and you don't follow it, that could be a very serious issue. Lack of an investigation, I think, is what drives many employees to go see lawyers like me. What ends up happening is that there are very few times that I've spoken to an employee, and again, I work on a lot of employer cases, but I do see employees that come in, right? If we're overbooked and the attorneys are busy that work on the employee cases, I will meet with the employee cases. All the employees, 99% of them, have always said the same thing. I don't want to meet with an attorney. I don't like meeting with an attorney. Apart from a car accident, workers' compensation, and maybe a divorce, maybe immigration, I never thought I would be in a law office, but my employer has done nothing. My employer has not done the investigation, therefore I'm here. And of course, what is the attorney going to say? I don't know if the employer did the investigation. We have to sue and we have to find out. And so it's very important not only that you do an investigation, that you do what an ideal employer would do, but you also notify the employee as to the status of the investigation. Let them be part of it. I think you'll find, earlier I used the example, I believe, of Sarah and Tim. I don't necessarily think if Sarah has a problem with Tim, she wants Tim to be fired. She wants Tim to be demoted. It's very rare that that ends up happening. What Sarah really wants is she just wants an investigation to be done, and she wants Tim to improve. And I think that if you as an employer are willing to do those steps that are necessary, you will find that Sarah is not going to go out and sue. Because what will end up happening, for example, is the law firm comes in, let's say they make the determination, we can't conclusively say yes or no that Tim sexually harassed Sarah. You go up to Sarah, you say, Sarah, the law firm made a determination that Tim, we can't really tell yes or no. But you know what? We're going to send Tim to a sexual harassment class. We know that everybody does sexual harassment classes, but he's going to do an extra one. And we're going to separate you and Tim. Sarah, you can work whatever shift you want, and Tim will work on the opposite shift. Are you okay with that? 99% of times, Sarah will say, okay. She'll sign on the dotted line and she'll say, I find that to be acceptable. And isn't that what you want as an employer? Is that although there's a lot of frustration that goes into place, yes, there's a lot of manpower and money that's necessary to do the reasonable investigation. In terms of the reasonable investigation, once that's conducted, you'll find typically that Sarah is very amenable, very calm, very relaxed. What ends up happening, again, just to repeat myself on purpose, is that a company does not do either an investigation, or they do a little investigation, or they do an investigation, they don't involve Sarah. And so Sarah is just left in the dark. And that's where I think many companies make the mistake in terms of the investigation process as it relates to employment disputes.
今天这是我们本系的内容，如果你喜欢的话，给我一个点赞、留言跟订阅，谢谢。